The first thing I noticed was the silence. Out here, tucked deep into the Blue Ridge Mountains of North Carolina, silence wasn't just an absence of sound. It was its own kind of music. The soft rush of the creek behind the cabin, the whisper of wind through the tall pines, the occasional crack of a branch far off in the woods. It was the language of peace. It was why I built this place. And that's why the envelope taped to my cabin door that September morning felt like a bullet through a prayer. It was just past 7 a.m. The air was crisp enough that I could see my breath as I stepped out with my coffee mug, planning to split a few logs before breakfast. That's when I saw it. A legal-sized envelope slapped against the red cedar door, flapping in the breeze. Bright white against the stained wood. I frowned and peeled it off. The return address read, Highland Ridge Homeowners Association, Compliance Department. I laughed, an incredulous bark that echoed through the still trees. Compliance Department? I muttered aloud. There's no HOA within 10 miles of here. Still, I tore it open. Notice of violation and assessment. Dear Mr. Carter, this letter serves as a formal notice that your property located at Lot 72, Highland Ridge Development, is in violation of several community ordinances, including but not limited to unauthorized construction, failure to submit design review plans, and disruption of common area views. Accordingly, the Highland Ridge HOA Board has assessed a fine of $50,000 payable within 60 days of receipt of this notice. Failure to remit payment will result in legal action, property liens, and other remedies available under North Carolina law. Sincerely, Margaret Cole, President, Highland Ridge Homeowners Association. I read the letter twice, then a third time, slower, as if somewhere between the legal jargon and threats, it would start to make sense. It didn't. Lot 72, Highland Ridge? I wasn't in Highland Ridge. I wasn't even near it. Their gated community was 3 miles down the valley, neatly paved streets and manicured lawns and matching mailboxes, everything my cabin wasn't. I'd bought these 10 acres precisely because they were unincorporated, unregulated, and untouched. I'd even confirmed with the county registrar before I built the place. No covenants, no restrictions, no HOA. And now they were telling me I owed them 50 grand? Yeah, right. I scoffed, crumpling the letter and tossing it into the fire pit. Good luck collecting. But even as I said it, something cold and sour settled in my gut. I spent the next hour pacing my porch, replaying the words in my head. Unauthorized construction. Disruption of views. $50,000. It was absurd, offensive, even, but the tone of the letter wasn't the idle bluster of some crank neighbor. It was legal, deliberate, like they'd already decided I was guilty and the fine was a done deal. I needed answers. By 10 a.m., I was rolling down the gravel road in my old F-150, heading toward Highland Ridge. The place was exactly as I remembered it, sterile and pristine, like a movie-set suburbia plopped into the wilderness. Stone pillars flanked the entrance. Highland Ridge, a premier mountain community, carved into granite. The gate guard, a retiree in a neon vest, barely looked up as I approached. Morning, I said, leaning out the window. I'm here to see the HOA office. He gave me a skeptical look. You a resident? Nope, I said. I'm a neighbor. Got a letter from them. That got his attention. He clicked a button, and the gate swung open. Straight ahead, clubhouse is on the left. Good luck, he added with a knowing smirk. The clubhouse was a sprawling timber and stone lodge perched on a hill, like a luxury ski resort lobby. Inside, everything smelled faintly of lemon polish and money. A young receptionist with perfectly ironed hair greeted me with a practiced smile. Welcome to Highland Ridge HOA. Do you have an appointment? No, I said, but I got this. I slapped a copy of the letter on the counter, and I'd like to know what the hell it's about. Her smile didn't falter, but her eyes flicked to the letter. Mr. Carter. One moment. She disappeared into a back office. 2 minutes later, she returned. Miss Cole can see you now. Margaret Cole looked exactly like the kind of woman who'd run an HOA. Mid-50s, silver bob, pearl necklace, eyes that measured everything and found most of it lacking. She was behind a heavy oak desk when I walked in, typing something on a laptop. She didn't stand to greet me. Mr. Carter, she said coolly. I assume you're here about the notice. Yeah, I said. I'm here because your notice says I owe you $50,000. And I don't even live here. She folded her hands. Your property sits directly adjacent to Highland Ridge's northern boundary. The original development plat designates that parcel as Lot 72, part of Highland Ridge. That's impossible, I snapped. I bought that land free and clear. It's not part of any HOA. She smiled like a teacher correcting a slow student. I've reviewed the deeds myself. The parcel was originally part of the Highland Ridge subdivision, but was sold before build-out. Regardless, the covenants run with the land. All owners are subject to them. I felt my jaw tighten. That's not what the county records say. County records are often incomplete, she said lightly. We have our own legal counsel. If you dispute the fine, you're welcome to pursue arbitration. Arbitration? I scoffed. I'm not arbitrating anything. Your HOA has no jurisdiction over my land. And you sure as hell aren't getting 50 grand from me. Her smile vanished. Mr. Carter, I strongly advise you to reconsider your tone. Non-payment can result in liens, foreclosure proceedings, even sheriff's sale. You'd be amazed how quickly legal fees add up. Is that a threat? It's a fact, she said flatly. You have 60 days. I stared at her, stunned by the audacity. Then I turned and walked out without another word. By the time I got back to the cabin, the sun was sliding low over the treeline. I stood on the porch and stared out over the valley, the same view that had stolen my breath the first time I saw it. A slice of paradise, my paradise. And now some HOA president with a superiority complex thought she could take it from me. Not gonna happen, I muttered. But bravado only went so far. That night, I sat at the kitchen table, laptop open, combing through property records and deed filings. It was true. My parcel had once been part of a larger tract owned by the Highland Ridge developer. But the subdivision plan they filed excluded this lot after it was sold to a private owner decades ago. The HOA had no recorded easements, no covenants, nothing. So why did they think they did? I called the county registrar the next morning. We've had a few calls about that, the clerk told me. Highland Ridge's lawyer's been poking around old plats, trying to argue some of those lots are still under their covenants. They're stretching, if you ask me. Can they even do that? Not legally, she said. But they can sure try. And it's a headache until it's resolved. A headache. That was one word for it. A $50,000 shakedown was another. Over the next 2 weeks, things got weirder. First, a notice showed up in my mailbox, certified mail this time. Another fine, plus late fees, now totaling $51,250. Then, I noticed a strange SUV parked just off the county road, its driver snapping photos of my cabin with a telephoto lens. And one morning, I came back from town to find a bright orange notice of noncompliance nailed to a tree on my property. It bore the Highland Ridge logo and warned of further legal action if I didn't remove my non-approved structure. I yanked it down and tore it in half. This is harassment, I growled. My sister, Julie, called that night. You sound stressed, she said. Everything okay? I sighed. HOA nonsense. Some rich busybodies down the road think they own my land. Can they really do anything? No, I said. At least I don't think so. But they're making my life miserable trying. She was quiet for a moment. You need a lawyer. Yeah, I admitted. I think I do. I met with one the next day, a grizzled property attorney named William Haynes who'd been practicing in the county for 40 years. He listened patiently as I explained everything, flipping through the letters I'd brought. When I finished, he leaned back and let out a low whistle. They're overstepping, no question. If your deed shows no HOA encumbrance, they don't have a leg to stand on. Then why are they doing this? Because they're betting you'll fold before you fight, he said. Most people do. It's cheaper to pay a few grand than pay lawyers. Well, I'm not most people. He smiled. Then we'll fight. First step, a cease and desist letter. I'll draft it tonight. It felt good, empowering, even, to take action. But that feeling didn't last long. Because 3 days later, I found something on my land that made my blood run cold. It was early morning, fog still clinging to the pines, when I hiked down to the southern edge of my property line, the part that bordered Highland Ridge. I'd noticed from the porch that something was different down there. And sure enough, when I reached the boundary, I stopped dead in my tracks. A fence. A brand new 6-foot-tall black iron fence stretching along the entire border on my side of the survey line. There was a sign bolted to one of the posts. Private property, Highland Ridge HOA. No trespassing. I felt my pulse spike. They hadn't just threatened legal action, they'd taken my land. I pulled out my phone and started snapping photos. Then I called Haynes. They built a fence, I said, breathless. On my property. What? On my land. They posted a sign claiming it's theirs. I heard him exhale slowly. All right. This just escalated. They're not posturing anymore. They're trying to establish adverse possession, which means they're laying groundwork to claim that land as theirs if you don't contest it. I stared at the fence, rage boiling in my chest. Oh, I'll contest it, I said. I'll burn the damn thing down if I have to. Don't do that, Haynes warned. We'll file an injunction. But be prepared, Carter. This is going to court. I ended the call and looked back at my cabin, its weathered timbers glowing softly in the morning light. It had always felt like a sanctuary. Now it felt like a target. Somewhere out there, Margaret Cole was probably congratulating herself, certain I'd cave. She had no idea who she was dealing with. Because this wasn't just about $50,000 anymore. This was war. The first papers hit my mailbox a week later. They were sealed in thick manila envelopes, stamped with the words Superior Court of Buncombe County in bold across the front. I didn't even have to open them to know what they were. Margaret Cole had made her move. Complaint and petition for declaratory judgment. The header read when I finally slit the envelope open at my kitchen table. The language was dense, bureaucratic, and sharp enough to cut. The Highland Ridge Homeowners Association was suing me for breach of covenants and restrictions and seeking a court order to compel compliance and recover damages. Damages, $50,000. Legal costs, unspecified. Jurisdiction, contested. I stared at the pages for a long time, my coffee going cold beside me. It wasn't a bluff anymore. Margaret had gone from threat to action, and she wasn't just trying to find me. She was trying to drag me into her arena, under her rules, in her court. And I'd be damned if I let her. Classic tactic, Haynes said when I slid the papers across his desk that afternoon. His office was cluttered and cozy, lined with dusty law books and framed newspaper clippings from cases he'd won decades ago. They're trying to get a declaratory judgment that your property is part of their HOA. If a judge signs off, that makes their covenants enforceable. But they're wrong, I said. You saw the deed. They are wrong, he agreed. But wrong and illegal aren't the same thing until a court says so. And right now, they're banking on the fact that most people don't fight this far. Well, I'm fighting. Good, Haynes said. Because this is going to be a war of inches. We'll respond with a motion to dismiss on jurisdictional grounds. If the court agrees your property isn't part of Highland Ridge, this whole thing dies before it starts. And if the court doesn't agree? He sighed. Then we're in for a long, expensive fight. The weeks that followed felt like living inside a storm. Every day brought something new. Another notice from Highland Ridge, another motion filed, another letter from their attorney dripping with thinly veiled threats. One particularly smug email read, "Our client remains confident the court will uphold the recorded covenants and compel Mr. Carter's compliance. We strongly advise your client to consider settlement to avoid escalating costs." Settlement. That word came up a lot. Margaret's lawyers hinted at it in every letter. Pay a reduced fine now, sign a compliance agreement, and this all goes away. They were counting on me to crack, to look at the mounting legal bills and cave. But I wasn't interested in peace. I wanted justice. By mid-November, our motion to dismiss was ready. Haynes walked me through every line before we filed. The key, he explained, tapping a highlighted paragraph, is proving that your parcel was excluded from Highland Ridge before any covenants were recorded. The developer's original plat shows your lot as part of a larger tract, but the revised plat, the one actually filed, excludes it. And that's enough? It should be, he said. Covenants can't apply to land that was never subject to them. And once land's conveyed without restrictions, they don't just magically appear later. I felt a flicker of hope. It was the first real foothold we'd had since this started. But Highland Ridge wasn't sitting idle. 2 days after we filed, Haynes called me into his office. "They've amended their complaint," he said grimly. "They're claiming your cabin encroaches on their common area." "What?" I blinked. "That's insane. My cabin's 300 feet from the boundary. They're citing a new survey, one they commissioned last week. According to them, your southern fence line cuts 12 feet into their land." I felt my hands curl into fists. Their land? They're the ones who built a damn fence on mine. "I know," Haynes said, "and we'll challenge that survey. But this tells us something important. They're shifting tactics. They're not just arguing covenants anymore. They're trying to redraw the map." It was time to dig deeper. I spent hours combing through county archives, scrolling through scans of decades-old subdivision plats, deeds, and surveys. Somewhere in the mess, there had to be proof, something undeniable that would shut this whole circus down. And then, buried in a 1987 filing, I found it. A notarized amendment to the Highland Ridge plat filed by the original developer. It explicitly removed 2 lots, including mine, from the subdivision before the HOA was formed. It was like finding a smoking gun. I called Haynes immediately. "You're going to want to see this," I said, emailing him the document. He called back 10 minutes later, his voice almost giddy. "This is gold, Carter. This isn't just evidence. This kills their case. If the HOA didn't exist when that amendment was filed, their covenants never touched your property. So we win." Not yet, but this puts us in the driver's seat. Our next filing hit them like a sledgehammer. Haynes attached the 1987 amendment as Exhibit A in a supplemental motion, arguing that Highland Ridge had no legal authority over my land by their own developer's admission. He even cited case law from North Carolina's Supreme Court. Covenants cannot bind property excluded from a subdivision prior to their adoption. A week later, we got our first reaction. A terse email from Highland Ridge's counsel. "We dispute the authenticity and applicability of the document in question and will address it at the hearing." Translation: they were rattled. And then, in what I can only describe as a tantrum, Margaret Cole herself showed up at my cabin. It was a Saturday morning, snow flurries dusting the ground, when her silver Mercedes crawled up my gravel drive. She stepped out in a wool coat and leather gloves, looking wildly out of place against the rough-hewn logs and muddy truck tracks. "Mr. Carter," she said, lips pursed. "We need to talk." I crossed my arms. "I don't think we do." "You're making a mistake," she said. "Dragging this into court is only going to cost you money. Money you won't get back even if you win." "Then why are you dragging it into court?" I shot back. "If you're so sure you're right, why the hard sell?" Her expression hardened. "Because you're standing in the way of progress. That cabin of yours is an eyesore. It lowers property values. It disrupts the continuity of Highland Ridge's aesthetic." I barked a laugh. "Aesthetic? Lady, I built that cabin with my own hands on land I own. Your aesthetic stops at your property line." She stepped closer, her voice dropping. "You think this is about money, but it's not. It's about control. And I promise you, Mr. Carter, you're not going to like what happens when people like me decide you're a problem." For a moment, the woods around us went silent. Just the 2 of us, standing in the cold, her words hanging heavy in the air. "See you in court," I said quietly. She turned and walked back to her car without another word. The first hearing was scheduled for mid-January. The courthouse in Asheville was a red brick monument to Southern justice, its wood-paneled courtroom steeped in the smell of varnish and history. As I sat beside Haynes at the defense table, I felt my pulse thudding in my ears. Across the aisle, Margaret sat prim and composed, flanked by 2 expensive-looking attorneys in tailored suits. She didn't look at me once. Judge Helen R. McAdams, a sharp-eyed woman with silver hair and a reputation for cutting through nonsense, took the bench promptly at 9 a.m. "Counsel," she said, "we're here today to address the defendant's motion to dismiss." Highland Ridge's lead attorney, a slick man named Porter, launched into a polished speech about community covenants and developer intent. He argued that my property was integral to the subdivision's original design and that equitable servitudes still applied, even if they weren't expressly recorded. It sounded impressive, until Haynes stood. "Your Honor," he said, holding up the 1987 amendment. "The plaintiff's entire argument rests on the premise that Mr. Carter's property is part of Highland Ridge. But this document, recorded 5 years before the HOA existed, explicitly removes his parcel from the subdivision. It was never subject to their covenants. Period." Porter objected, calling the document inconclusive, but McAdams wasn't buying it. "Counsel," she said sharply, "if the property was excluded prior to the creation of the HOA, you have a serious problem. I'm inclined to agree this court may lack jurisdiction." The tension in the room shifted. Margaret's lips tightened. Porter shuffled his papers, but then he played his trump card. "Your Honor," he said smoothly, "even if Mr. Carter's property is technically outside the subdivision, his structure encroaches on our common area. We have a right to enforce our boundaries." He produced their new survey. McAdams frowned as she flipped through it. Haynes rose again. "We dispute that survey's accuracy, and we have photographic and GIS evidence showing the HOA's own fence crosses into Mr. Carter's land." The judge sighed. "All right. It's clear this case involves factual disputes that cannot be resolved today. I'm denying the motion to dismiss. This matter will proceed to discovery." It wasn't a win, but it wasn't a loss either. Outside the courthouse, Haynes clapped me on the shoulder. "They dodged the bullet today, but they're on shaky ground, Carter. That amendment is a dagger. Now we just need to aim it right." Over the next month, discovery turned my life into a paperwork storm. Every email I'd sent, every contractor I'd hired to build the cabin, every scrap of communication about my property, they wanted it all. And we wanted theirs: board minutes, internal emails, original plats, anything that showed they knew they were overreaching. And buried deep in a batch of documents Highland Ridge reluctantly turned over, we found something damning. It was an internal email from Margaret Cole to the HOA board, dated 2 months before I received that first letter. Lot 72 was excluded from the original covenants, but we cannot allow that cabin to remain unchecked. If we establish jurisdiction now, future buyers won't question our authority. Haynes read it twice, then looked up at me, grinning like a wolf. "This isn't just overreach," he said. "It's premeditated fraud." I stared at the email, a slow fire building in my chest. They knew they had no authority, and they tried to steamroll me anyway. That night, as I stood on my porch under a sky full of stars, I felt something shift. This wasn't just about saving my land anymore. It was about holding people accountable. People who thought their money and power made them untouchable. "Game on," I whispered to the dark, because now I had something stronger than anger or fear. Now I had proof. The trial began on a gray Monday morning in early March, the kind of morning where the sky feels heavy with something waiting to break. By then, 5 months had passed since the first letter showed up on my cabin door. 5 months of motions and countermotions, depositions and discovery battles. 5 months of watching a place I'd built with my own hands turn into a chessboard in someone else's game. And now it all came down to this. Inside courtroom 3B, the air was thick with tension. A row of Highland Ridge residents filled the gallery seats behind Margaret Cole, dressed in their Sunday best, like they were attending a country club luncheon instead of a legal showdown. Across the aisle, I sat beside Haynes, a stack of binders at our table, and a knot of adrenaline twisting in my chest. "Remember," Haynes murmured, leaning close. "Stay calm. Let the evidence do the work." I nodded, eyes fixed on the double doors as Judge McAdams swept into the room. "All rise." Porter opened for the plaintiff, his voice smooth as silk and twice as slippery. "This case," he said, "is about fairness and community. Mr. Carter's property was once part of Highland Ridge. His cabin disrupts the harmony of the neighborhood and encroaches on protected common space. Our covenants, which apply to all lots originally within the development, are essential to maintaining property values and quality of life. Mr. Carter's refusal to comply harms not just the association, but every homeowner in Highland Ridge." He paced slowly before the jury, weaving a tale of civic duty and shared responsibility. And I could see some of them nodding. Because who doesn't want community and harmony? Then Haynes rose. "Ladies and gentlemen," he began, his Carolina drawl steady and clear. "This case is not about community. It's about control. The Highland Ridge HOA is attempting to enforce covenants on land that is not, and never has been, under its jurisdiction. They know this. They've known it from the beginning. And they filed this lawsuit anyway." He held up a copy of the 1987 amendment. "This is the original plat amendment, filed 5 years before Highland Ridge existed. It explicitly removes Mr. Carter's parcel from the subdivision. That means their covenants cannot, legally cannot, apply to his land." He turned to the jury, his voice dropping low. "Ask yourselves why they pursued this anyway. Ask yourselves why they built a fence on land they don't own. Ask yourselves why they threatened foreclosure over property that isn't theirs. The answer is simple: because they thought they could get away with it." It was a masterful opening, and for the first time, I saw Margaret's composure falter. The next 3 days were a blur of testimony, exhibits, and cross-examinations. Highland Ridge called their developer first, a balding man named Richard Holmes who'd built the community in the 1990s. Porter led him through a rehearsed testimony about original subdivision intent and master plans, trying to suggest my land had always been part of Highland Ridge in spirit, if not in name. But Haynes eviscerated him on cross. "Mr. Holmes," he said, holding up the 1987 amendment, "is this your signature?" Holmes shifted uncomfortably. "Yes." "And does this amendment remove Lot 72 from the subdivision plat?" "Yes." "And was this amendment recorded before Highland Ridge HOA was formed?" "Yes." "So, to be clear, when the HOA was created, Lot 72 was not part of the subdivision. Correct?" Holmes hesitated, then nodded. "Correct. Thank you. No further questions." That was the moment the tide shifted. Even some of the HOA residents in the gallery exchanged uneasy glances. Then came Margaret. Porter tried to paint her as a tireless volunteer, a woman simply trying to protect her community from non-compliant structures and unsightly developments. She spoke with practiced authority, every sentence dripping with self-righteousness. But Haynes wasn't about to let her skate. "Ms. Cole," he began, flipping through a stack of papers, "you testified that you believed Mr. Carter's property was subject to HOA covenants. Correct?" "Yes." "And you stated that belief was based on your review of the original development plans?" "Yes." "Then how do you explain this?" He held up a printed email, and read it aloud for the courtroom to hear. "Lot 72 was excluded from the original covenants, but we cannot allow that cabin to remain unchecked. If we establish jurisdiction now, future buyers won't question our authority." Margaret's face drained of color. "Is this your email, Ms. Cole?" She shifted in her seat. "It was part of an internal discussion." "Answer the question. Did you write this?" "Yes," she said, her voice barely audible. "So you knew Lot 72 was excluded, and yet you pursued enforcement anyway." "I was acting in the best interest of the community." Haynes took a step closer. "The best interest of the community, or your own interest in expanding your HOA's power?" Porter objected. "Speculation." "Sustained," McAdams said. "Rephrase." "Ms. Cole," Haynes said calmly, "were you aware that your board's actions could result in financial harm to Mr. Carter?" Silence. "Then, yes." "Were you aware that the covenants did not legally apply to his land?" A pause. "Yes." The courtroom buzzed. Margaret shifted again, her poise crumbling under the weight of her own words. "No further questions," Haynes said, and walked back to our table. The defense's turn came on the 4th day. We started with the basics: the deed, the plat amendment, the county assessor's records, every scrap of evidence proving my property's independence. Then Haynes called our surveyor, a meticulous man named Don Avery, who dismantled the HOA's encroachment claim piece by piece. "Based on your professional survey," Haynes asked, "does Mr. Carter's cabin encroach on Highland Ridge property?" "No," Avery said firmly. "In fact, the HOA's newly constructed fence crosses approximately 14 feet into Mr. Carter's parcel." The jury murmured. Porter objected, but McAdams overruled. Finally, Haynes called me. I took a deep breath and walked to the stand, palms slick with sweat. Porter tried to rattle me with questions about permits, construction timelines, even the paint color of the cabin, but none of it stuck. When Haynes stood for redirect, he asked just one question. "Why did you build this cabin, Mr. Carter?" I swallowed hard. "Because I needed peace," I said. "I spent 20 years in construction, working 60-hour weeks in Charlotte. My dad taught me how to build things with my hands. When he passed, I promised myself I'd make something that lasted, something of my own. That cabin, it's my dream. It's where I plan to retire. And I followed every law and every regulation to make it happen." I glanced at the jury, my voice tightening. "And now I'm here because a group of people I don't even live near decided they could bully me into giving it up." Haynes nodded. "Thank you." I stepped down to a ripple of sympathy in the gallery. Even some of Highland Ridge's own residents wouldn't meet Margaret's eyes. Closing arguments came on the final day. Porter doubled down on his narrative of community rights and original intent, but his words felt hollow now. Too many cracks had formed. Too much truth had been dragged into the light. Then Haynes stood, buttoning his jacket. "Ladies and gentlemen," he said, "this case is about more than one man and one cabin. It's about whether a private organization can overstep its legal bounds and seize authority it does not have. The plaintiff knew this property was excluded. You heard it in their own words. And yet they threatened Mr. Carter with fines, liens, even foreclosure, all to expand their power." He turned slowly, meeting each juror's gaze. "If they win today, it sets a dangerous precedent that HOAs can ignore the law and rewrite property lines to suit themselves. But if they lose, it sends a different message, that property rights still mean something, that a man's land is his, no matter how powerful the people trying to take it." He stepped back. "We trust you'll make the right choice." The jury deliberated for 6 hours. I spent every minute of it pacing the courthouse hallway, heart thudding, stomach twisted in knots. Haynes sat calmly on a bench, sipping coffee like he'd seen this movie before. "They're going to see through it," he said. Cole overplayed her hand. "I hope you're right." When the bailiff finally called us back into the courtroom, I could barely breathe. "Madam Foreperson," Judge McAdams said, "has the jury reached a verdict?" A woman in the front row rose, a folded piece of paper in her hands. "We have, Your Honor." She handed it to the clerk, who read aloud. "In the matter of Highland Ridge Homeowners Association versus Daniel Carter, we the jury find in favor of the defendant on all claims." My knees nearly buckled. It wasn't just a win. It was a complete victory. The HOA's covenants didn't apply. Their fence was illegal. Their fines were void. Every single claim they'd brought against me was thrown out. But it wasn't over yet. Judge McAdams leaned forward. "Furthermore," she said, "this court finds evidence of bad faith litigation by the plaintiff. Mr. Carter is entitled to recover legal fees and damages incurred as a result of this suit. A separate hearing will be scheduled to determine that amount." The gallery erupted, gasps, whispers, a few scattered cheers. Margaret Cole sat frozen, pale and stone-faced, her empire crumbling around her. And I just closed my eyes and let the breath I'd been holding for 5 months finally escape. Outside the courthouse, snow was falling softly, blanketing the steps in white. Reporters had gathered, small-town papers mostly, but enough to turn heads. One shoved a microphone toward me. "Mr. Carter, how does it feel to win?" I thought about the sleepless nights, the fear of losing my home, the sheer audacity of what they'd tried to do. "It feels," I said, "like the little guy finally won one." And somewhere deep in my chest, for the first time in months, the knot of anger and fear loosened. But as Haynes reminded me quietly while we walked to the truck, we're not done yet. Next comes the damages hearing. And something tells me the court's going to have a few questions for Mrs. Cole. I nodded, eyes lifting to the horizon where the mountains stretched long and endless beneath the winter sky. The war might be won, but the reckoning had only just begun. The morning of the verdict arrived draped in a stillness that felt almost ceremonial. September sunlight poured through the tall windows of the Fairfax County Courthouse, washing the marble halls in gold. It was the kind of morning where the air itself seemed to hold its breath, as if the world was waiting for something monumental. Daniel Carter stood by those windows, gazing down at the square below where news vans and camera crews had gathered. 4 weeks now, his name had been whispered in living rooms and splashed across local headlines. Man sues HOA over illegal fine. Can a homeowners association overreach its power? He'd never asked to become a symbol. But somewhere along the way, that's what he'd become. The man who said no when everyone else stayed silent. "Hey," said Sarah, coming up beside him. She placed a gentle hand on his arm. "You ready for this?" Daniel exhaled slowly, his chest tight. "Ready as I'll ever be." They walked into the courtroom together. The same oak benches, the same stern-faced judge, the same trio of HOA board members sat at the defense table, though they looked far different now. Margaret Cole's once unshakable composure had cracked into visible anxiety. Robert Harlan, the HOA president, shifted uneasily in his seat, glancing at the reporters in the back row. Even their attorney, the famously sharp-tongued James Pierce, seemed subdued. The past 2 weeks had been a relentless storm of testimony and evidence. Evan had dissected their covenants and bylaws with surgical precision, showing line by line that the HOA's reach ended miles before Daniel's cabin property. The GIS surveyor had demonstrated, using maps and historical plats, that the cabin had never been under the HOA's jurisdiction. And when subpoenaed emails revealed the board had known this fact but pursued the $50,000 fine anyway, a gasp had rippled through the courtroom. Now, it was Judgment Day. "All rise," the bailiff announced as Judge Marjorie Winslow entered, her robe flowing like a shadow across the polished floor. The room stood silent as she took her seat and adjusted her glasses. "You may be seated," she said, her voice steady and deliberate. She glanced over the docket, then lifted her gaze toward the courtroom. "We are here today for the final judgment in Carter versus Autumn Ridge Homeowners Association." Daniel's heartbeat thudded in his ears. Judge Winslow paused, letting the weight of the moment sink in. After reviewing the evidence, testimony, and applicable law, the court finds that the Autumn Ridge Homeowners Association acted outside its legal authority when issuing a $50,000 fine against Mr. Daniel Carter for his property located at 117 Pine Hollow Road. Margaret closed her eyes. Robert sank slightly into his chair. The property in question lies beyond the territorial jurisdiction defined in the HOA's founding documents, as amended and recorded with Fairfax County. Therefore, the HOA had no legal authority to regulate, fine, or otherwise enforce its covenants upon Mr. Carter. Daniel gripped Sarah's hand. Her fingers trembled with his. The judge continued, her tone now sharpening. "Furthermore, evidence presented indicates the HOA board was aware of this jurisdictional limitation and proceeded with enforcement actions regardless. This constitutes not only negligence but deliberate overreach and harassment." A murmur swept through the courtroom. The board member's attorney stared down at his papers, avoiding eye contact with anyone. Accordingly, Judge Winslow said, "This court orders the following. The $50,000 fine levied against Mr. Carter is null and void. The HOA shall issue a formal written apology within 14 days. Additionally, the HOA is ordered to pay Mr. Carter $175,000 in compensatory damages for emotional distress, legal fees, and reputational harm." Daniel's breath caught. $175,000. It wasn't about the money. It never had been, but hearing it spoken aloud felt like a vindication deeper than words. "And one final matter," the judge said, her voice now cool and commanding. "This court refers evidence of potential fraud and abuse of authority by individual board members to the county district attorney's office for further review and potential criminal charges." The room exploded into noise, reporters firing off questions, camera shutters clicking like gunfire. Margaret's mouth fell open. Robert turned pale as a sheet. Judge Winslow rapped her gavel sharply. "Order. This court is adjourned." And just like that, it was over. Outside the courthouse, the autumn air was crisp and sweet, smelling faintly of rain on fallen leaves. A swarm of microphones and cameras closed in around Daniel as he stepped onto the courthouse steps. "Mr. Carter, how does it feel to win? Do you think this will change how HOAs operate nationwide?" Will you pursue criminal charges? Daniel blinked at the sea of flashing lights and eager faces. Just months ago, he was a man who wanted peace and quiet in a cabin he built with his own hands. Now he was standing here as the guy who had taken on an HOA and won. It feels, he said slowly, his voice steady despite the whirlwind, like the system worked. This wasn't just about me. It's about accountability. Homeowners shouldn't live in fear of organizations that think they're above the law. And today proves they're not. Sarah slipped her hand into his, and the crowd surged forward with more questions. But Daniel only smiled, nodded politely, and walked toward the parking lot. He had nothing left to prove. The weeks that followed were a blur. News of the case spread far beyond Fairfax County. National outlets picked up the story. HOA reform groups hailed Daniel's victory as a landmark decision. Forums buzzed with debates about property rights and overreach. The Autumn Ridge HOA scrambled to contain the fallout. 3 board members, including Margaret Cole, resigned under mounting pressure. A 4th was subpoenaed as part of the county's criminal investigation into misuse of funds and abuse of authority. By winter, a newly elected board promised sweeping reforms and strict adherence to jurisdictional limits. And as for the $175,000 judgment, Daniel used part of it to finish the renovations on his cabin, not extravagantly, but exactly the way he'd always envisioned. He replaced the old wood stove with a new stone fireplace, built a wraparound porch overlooking the valley, even planted a grove of aspen trees near the waterline, their white trunks standing sentinel against the changing seasons. But the money wasn't the real victory. The victory was the peace that returned. One crisp November afternoon, Daniel stood on that porch with a mug of coffee, watching the last amber leaves swirl down from the trees. A truck pulled up along the gravel path. Evan stepped out, carrying a manila folder under his arm. "Hope I'm not interrupting your mountain solitude," Evan said with a grin. "Not at all," Daniel replied. "Come on up." They sat on the porch steps, steam curling from their mugs. "Got a letter from the county DA," Evan said, tapping the folder. "They're pursuing charges against Cole and Harlan. Fraud, abuse of authority, and a couple of counts of mail tampering tied to those fake enforcement notices." Daniel raised his brows. "Mail tampering? That's federal, isn't it?" "Yep," Evan said. "If they're convicted, they're looking at real penalties. It's not just fines anymore." Daniel stared out over the valley. "I never wanted them in jail. I just wanted them to stop." "I know," Evan said. "But this is how you stop people like them from doing it again." They sat in silence for a while, listening to the rustle of wind through the pines. A hawk circled lazily overhead. "By the way," Evan added, "I've had 5 new clients this week, all folks dealing with HOA overreach. Looks like your case opened some floodgates." Daniel chuckled. "Glad I could help your business." "Hey," Evan said, standing and patting him on the shoulder. "You helped more than just me. You reminded a lot of people that the law still matters, that they don't have to back down just because someone with a title says so." After Evan left, Daniel walked down to the water's edge. The lake mirrored the sky in perfect stillness. He thought about the man he was a year ago, tired, angry, feeling small against something bigger than himself. And then he thought about the man standing here now. It wasn't about cabins or fines anymore. It was about dignity, about standing up when something was wrong, and about the quiet power of refusing to be bullied. A gentle breeze stirred across the water. Daniel smiled faintly and turned back toward his cabin, the sun setting behind the mountains in a blaze of orange and gold. For the first time in a long time, the world felt right again. Months later, a small brown envelope arrived in Daniel's mailbox. No return address. Inside was a folded piece of stationery, handwritten in careful, looping script. "Mr. Carter, I owe you an apology, not the kind the court ordered, but the real kind. I believe the HOA was above reproach. I was wrong. I see now that we abused our position and hurt people in the process. I don't expect forgiveness, but I wanted you to know I'm truly sorry. Margaret Cole." Daniel read the letter twice, then folded it gently and tucked it into a drawer. He didn't need revenge. He didn't need bitterness. The law had spoken, the truth had won, and life, real, peaceful life, had returned. And in that peace, Daniel Carter knew something with absolute certainty. No matter how powerful they think they are, no one, not even an HOA, is above the law. If you enjoyed this intense story, smash that like button and subscribe for more gripping, cinematic tales. Don't forget to hit the bell so you never miss the next thriller. Your support keeps these stories coming.